very warm welcome to all of you to our first of a series of the Primary teleseminars. It's certainly a unique experience for all of us, but it's been no mean feat putting together this series, and particularly in the new world in which we operate. I think it's a testimony to our group's adaptability and responsiveness, and certainly evidences our intent to try and provide up-to-date information and up-to-date collation of series of issues for the benefit of our clients. I think many of us are operating under nationwide and in some instances also almost continent-wide lockdown, and that certainly presents its own challenges. I'd like to thank our marketing team for putting on such a series like this. It's no mean feat, as I say, again, including a diverse panel of experts to discuss a broad range of issues that we will today, is testimony to the group's depth, and I'm very confident that these discussions will prove beneficial to all of you who join us today. I'm most grateful to all of our panelists for committing to the series, and again in doing so in such a short space of time. I saw recently on the news that the International Monetary Fund has compared the COVID-19 pandemic business world to one which almost existed during the 20th century's Great Depression. I think simply operating a business in an environment like that is beyond measure incredibly tough. Understanding the new legal landscape across the continent and how that may impact on businesses appears insurmountable. I think our diverse panel is going to do a great job in distilling these issues with some clarity and to your benefit. I hope also that you'll all join us for the forthcoming series, which we plan on rolling out. There's one next week and then again in the months to come. And I'd hand over to my colleague Andreas to take you through each of the panelists. Thank you very much, all of you, for attending this, the first of our series.
Thank you, John, and welcome audience members, wherever you may be across the globe. I hope you're safe and sound. We'll dive right in. I will introduce each panel member very, very briefly as they speak, rather than all in advance. But just by way of a very brief overview, we will have the Honorable Judge Boulel from Mauritius. We have Mweshi Mutuna from Zambia, a legal practitioner there. We have Anthony Norton from South Africa, a renowned competition lawyer. We have Fidel Mwaki from Kenya in Nairobi, also a business lawyer and counsel to companies there. And we have Gilbert Noel from Mauritius, our local practice lead on the island. So, Your Honor, Judge Boulel, why don't you introduce the topic for us from your perspective, how you see the commercial path forward, as the title of today's seminar states, regarding the legal implications, perhaps even the philosophical implications as to the COVID-19 pandemic and its impact on businesses and contracts.
Hi everybody, and thank you for having me on board. Maybe I'll start with a quote from Shakespeare. Neither a lender nor a borrower be. If you had complied with this, we would not have been in that situation today. The coronavirus presents a unique situation. Unique in the sense that, excluding for the time being the issues raised by force majeure, whether it was foreseeable, predictable, whether measures could have been taken to contain its spread and all that, but it is a unique situation that the world maybe has not faced in recent times. Now, most businesses, most companies are going through difficulties to fulfill their obligations and their contracts, to comply with their contractual duties and all that. Does that mean that a company who is faced with that virus today can just stay put and invoke the force majeure when the other party, for example, a bank says, hey, come on, pay me my loan? Let me start with how the WHO has described the pandemic. it said that it implies a situation that is serious, unusual, or unexpected, carries implications for public health beyond the affected state's national border, and may require immediate international action. When you read what the WHO says, what the WHO says, it's as if it is encompassing all the rules in regard to force majeure. Would that definition be enough by itself for a contractual party to invoke force majeure? First question. Because it is very wide. Now, we all know what force majeure is. It is an event that could not be foreseen. It is an event that is beyond the control of a party, and which makes it impossible for a party to fulfill his part of the bargain. Now, many contracts do contain force majeure clauses. Some contracts have a blanket formula. Some contracts have specifics, including epidemics and pandemics. But that does not mean that just including epidemic or pandemic in a contract will necessarily result in a successful application of the force majeure in a contractual obligation. In Mauritius, for example, the concept of force majeure is recognized in the civil code, just like in France. Mauritius has a hybrid system, and our civil code is based on the civil code of France. Now, what happened, and I compare with France because the new civil code of France has certain principles which might help us, though these provisions will not apply to countries across the globe, but the principles embodied in these provisions of the civil code may help us to think how to deal with the issue of force majeure in the present context. In France, they have what we call a hardship provision clause. In French, it is called imprévision. What this clause says is that when it is impossible for a contract to be performed because of a change in circumstances that was unforeseeable at the time of signing the contract, one party may ask the other party to renegotiate the contract. And I find this very interesting. This is a principle that we might use, that companies may use to renegotiate when the danger is impending. And if the negotiations is not successful, then the parties can go to court and ask the judge to requalify the contract or to put an end to the contract if time was the essence of the contract. Now, this is a bit the situation in Mauritius. If, for example, in spite of that renegotiation, the contract has become nugatory, then the contract is at an end. I believe this provision is a very interesting one because it might help, as a matter of legal argument, companies to use this as a means of renegotiating. And my advice would be, when companies are facing difficulties or a contractual party is facing difficulty, don't stay put, don't wait and see, negotiate, be proactive. This is what I would believe should be done. But then, in the face of the coronavirus, should we only rely on force majeure clauses to get out of a tight situation? Or should we also look out for other solutions? For example, should we wait or should we ask for a government intervention? Because, for example, in Malaysia and in Australia, the amount for a statutory demand has been increased. The delay within which you can ask for a winding up has been increased. The delay for statutory demand has been increased from 21 days to 60 days. So government intention is trying to ease the burden on companies, notwithstanding whether force majeure will be successfully invoked or not. And in Mauritius, the government has announced a series of measures to help companies and individuals in view of the impact of the coronavirus, including moratorium on capital repayments of loans, restructuring of loans, and the provision of extension of period of payment of loans. So, whether we fall back on force majeure or not, I believe negotiations in these difficult times is one of the key issues we should adopt.
Thank you, Judge. I think that's a good caesura, a good incision point there to move to Mweshi Mutuna's presentation on the practical application of those principles that you suggested in your opening talk. Mweshi, Judge Boulel mentioned a few of the options, such as early renegotiation. He advised parties, generally speaking, to be proactive rather than reactive and wait. What is your perspective, and what have you seen thus far in your practice?
Okay, my perspective is that that is a wise step to take. We negotiate contractual terms at the earliest possible opportunity, but before even doing that, party COVID-19 pandemic, because it's very doubtful that every single term or obligation in your contract will be affected by the pandemic. Performance may still be possible, although made more difficult or expensive. So those are things that parties will have to look at. The other thing that I think is the turning on the ground here in Zambia is, apart from wanting to renegotiate contractual terms, parties are also considering the option of suspending performance, where you can actually show causation between COVID-19 and performance of an obligation. Of course, there may be pushback from the party who is not affected in performance terms. Perhaps their obligation is to receive delivery of goods and merely make payment for it. So the payment obligation is not affected, but delivery may be affected by quarantine requirements, lockdowns, and such like. So that is something that is being looked at locally. Renegotiating, either rewording when performance of an obligation will be done, suspending performance until indefinitely or until a later stage. And there's also termination. Termination is being viewed as one of the solutions to dealing with this. So that is what we're seeing here.
And Mweshi, your practice is obviously somewhat international as well, Pan-African, and not only focused on Zambia. And to pick up on what Judge Boulel mentioned earlier about government intervention, what strikes me in that regard is any given nation, any given jurisdiction may have its own measures to respond legislatively or in rulemaking to the COVID-19 crisis within its borders. However, don't you see international business contracts as well that transcend borders and that are therefore affected by at least two, if not more, different jurisdictions that may react differently, that may have enacted different packages, legislative response packages? And so do you advise, for example, going forward for parties to avoid having to navigate this complex web of different jurisdictional systems, do you advise parties to include a specific clause in their force majeure provision that would include the term pandemic or the like? Or do you even see that yet?
Actually, there was an agreement that I was looking at a few months ago, and it actually included epidemic and pandemic as a force majeure event. It was influenced by an English contract that was drafted arising from the SARS 2003 epidemic. So quite a few contracts locally would have epidemic and pandemic as a force majeure event, but that is not very common. So obviously going forward with the type of cross-border effect that COVID-19 has had, it's a very, very crucial clause to have.
Right.
Force majeure clauses should now include epidemic and pandemic. Although even when you have it, there's still a question of causation when it comes to performance. So it doesn't mean that it's a given. So that's advice that we're obviously looking at giving clients. That even if you include epidemic and pandemic in a force majeure clause, that is not a slam dunk in terms of enforcing it.
Right, especially in the African context, we now see that there's apparently a locust, a plague of locusts in Eastern Africa. I mean, when you combine these factors, it can get very complex. Thank you, Mweshi. And moving on to our next panelist, Anthony Norton in South Africa. Let me introduce your topic by asking a sort of provocative question. I personally have become fond of motorcycling, and the motorcycle GP, the Formula One of motorcycle racing, has now announced that their big teams all agreed amongst each other that they would not develop their engines for an entire season as a result of COVID-19. So that's essentially collaboration and cooperation amongst horizontal competitors like Honda, Ducati, and Yamaha. Would that violate the laws in South Africa, you think, or are there exemptions being made to cater for the effects of the pandemic on the collaboration of competitors?
Andreas, that's a very good question. And I want to focus my remarks briefly this morning on antitrust stroke competition considerations. I think what this COVID-19 pandemic has revealed is unprecedented cooperation between parties who were previously competitors across a range of industries and sectors. And, you know, from a local South African point of view, we've seen that in the context of the hospital sector, in the context of the property and retail sector, you know, virtually across entire industries, competitors are cooperating with each other in various guises and respects in order to try and marshal their resources in an optimal manner to address this epidemic or pandemic. In order to ensure that parties are acting in accordance with local antitrust or competition laws here, a number of parties and a number of industries have applied for so-called block exemptions. Those of you familiar with European competition law will be familiar with this notion of block exemptions, which often apply to particular sectors and industries. And that's what's happened from a South African point of view. So block exemptions for the duration of the pandemic, and specifically in relation to the pandemic, have been granted in relation to the hospital sector, the property sector, and various other sectors, in order to enable competitors to engage with one another in a lawful manner. And obviously this is quite crucial, because certainly in South Africa and in other jurisdictions like the United States and in the UK, competition law violations are now criminal. So one doesn't want to inadvertently end up in a worse position by trying to take meaningful and suitable measures to address the pandemic, and then find that later down the line, when regulators have had an opportunity to consider all the facts, that they then institute criminal and other civil charges against the parties concerned. So certainly, you know, we've spent a lot of time here locally in trying to ensure that our various clients are acting lawfully by getting block exemptions in order to enable them to address this collectively with competitors in certain respects, but stay on the right side of the law and not end up acting unlawfully. And I don't think that this is an issue confined to South Africa. I mean, you've seen this across the board in various countries where, you know, competing hospital groups, competing industrial groups have effectively tried to marshal their resources and act collectively in order to ensure that there are sufficient hospital beds, that there's sufficient supplies of oxygen, that there's sufficient supplies of food, that supply lines are not disrupted, you know, in this particular context. And I think the banking sector is another key area. I mean, obviously in the United States, you know, federal regulators and national regulators wanted to ensure there were sufficient supplies of dollars, and that's both a national phenomenon in the United States as well as internationally. And obviously banking groups have had to cooperate in order to ensure that there's sufficient liquidity in various financial markets. So I think collective action is a very necessary development in the current circumstances, but obviously making sure that parties stay on the right side of the law is crucial. And that's why I think block exemptions and those types of exemptions are critical to make sure that all of this can happen in a lawful environment. The one exception, and this is one of my favorite hobby horses, which I'm afraid I have to mention for the sake of completeness, is OPEC and oil. And you know, they are the one body which seems to be totally exempt and immune from antitrust and competition laws. And you know, we've seen recently President Trump even getting involved with the various OPEC members to try and negotiate limitations on supply of oil into the market to try and prop up the oil price. And you know, that's the one sort of obvious departure from normal competition laws where, you know, OPEC has never had to get antitrust exemptions, etc. So it's the one really glaring example out there where parties don't have to get antitrust exemptions or immunity in order to really operate with impunity from a competition law point of view. So those would be my opening thoughts and suggestions.
Thanks, Anthony. And of course, I am hearing through my spidey sense, without even looking at the audience members' questions, that they find it interesting that the one South African practitioner is highlighting the OPEC sector and not the diamond sector in that regard, regarding legal and operating with impunity large groups. But I hear you. I mean that facetiously, of course. I hear you. And it is actually ironic that the oil price has or gasoline price has significantly decreased, you know, during this time, because obviously there is less demand for cars and other, you know, factory outputs, etc. during this time. And so surprisingly, these supply and demand invisible hand, Adam Smith principle actually does apply a little bit even to the OPEC cartel, which the COVID-19 crisis has shown us, at least here in the US. I don't know, has the price come down in South Africa as well, Anthony?
Yeah, it certainly has. And, you know, as you quite rightly point out, despite various interventions, both formally and informally, that doesn't seem to have succeeded in propping up the oil/gasoline price. And certainly we've seen it come down in South Africa, which is one of the few merciful positives from this whole pandemic.
Right. If you could only legally drive now, that would and use all that cheap gasoline. Fidel, my colleague from Kenya, can you enlighten us on the impact that COVID-19 has or may have going forward on the fields of real estate and or the concept of the employee-employer relationships?
Yeah, so in real estate, you'll find that force majeure clauses are not consistently used. So really it depends on the different types of transactions that parties engage in. So for example, those parties that do one-off transactions. So one-off transaction will be a sale between me and X person, whereby it's time constrained, say 30 to 60 day or 90 day completion period. If one party defaults, there's a mechanism therefore for the other party to redress. The issue of force majeure wouldn't really arise in such a scenario. So what is happening is that such transactions are actually being delayed because of COVID-19, but this is because, say, the government registries have been shut down, certain procedures that happen there aren't happening at the moment. So what is happening is transactions are being delayed, but parties are not exactly or actually invoking any force majeure provision that may or may not be there. But when you consider things like construction, the construction industry, there a developer would certainly have the good sense to have a force majeure provision in his contract with his investors, so that, you know, of course now COVID is there. There's delays in construction. Supply chains are being disrupted because construction materials cannot be transported. Workers cannot get to their workplaces because of social distancing. So developers would be able to invoke force majeure. Of course, there's that debate on if it's an epidemic, pandemic, but you know, such wording would be in those contracts. The good thing is that it allows the developer to just communicate with the investors and see whether they can reach some accommodation. Another important area is commercial leasing in Kenya. So we're having a lot of problems with tenants not being able to pay their rents. And of course, in Kenya, we have a law that is very tenant friendly, which means landlords try as much as possible contractually to limit any disruption to rent payments. Leases don't have termination clauses if they're commercial leases in Kenya. So a tenant is essentially stuck in a lease for the duration of the lease period. They can't invoke a force majeure provision because the landlord would never have accepted to have it in there in the first place. So what you're seeing is landlords and tenants trying to look for a pragmatic approach to try and resolve their issues. We're seeing rent concessions, we're seeing landlords allowing terminations or early surrenders of leases. With employment, again, force majeure clauses are just not common in employment contracts in Kenya. Employment contracts in Kenya have to conform to certain minimum standards under our employment laws. So as much as an employer may feel that they can use COVID-19 as a way to invoke force majeure, they still have to comply with certain requirements under the law. So for example, if they want to reduce salaries or tell employees to go on unpaid leave, they can't just impose it on an employee. They have to sit down, consult, and agree with the employee on a mechanism for them to be able to achieve that. So it's not a matter of the employer imposing conditions on the employee. And again, it's really a matter in such cases, especially in the Kenyan context, where employees, employers, or business people, landlords, tenants, there has to be that discussion going on so that they all understand what's happening.
Thank you, Fidel. Do you foresee, regarding the construction and development side of things, do you foresee that there will be a lot of resolution or attempted resolution outside the judicial system, outside the courts, between the parties, given that this really affects virtually every entity in the vertical transactional pyramid, so to speak?
I think that would be better. What may be problematic is if after the pandemic has ended and delays continue to happen. There you can see parties now getting frustrated and seeing things that, you know, the building's not coming up, COVID-19 has ended, what's the solution now? But while the pandemic is in force, I think parties are much more flexible and willing to sit down and reason it out.
Right. I think we all see that in our respective jurisdictions, and panelists who disagree should chime in. But that obviously litigating disputes related to delays or impossibility due to the pandemic is obviously the last resort because it's simply costly. courts are often shut down for regular business and really only open for emergency motions, criminal habeas corpus type cases, etc., and are not even accepting urgent sort of motions for mere business cases. Do you advise, Fidel, last question to you on this, that what you just raised regarding the post-pandemic period, do you advise parties that are currently negotiating amongst each other and that are agreeing on some sort of compromise regarding delays, do you advise them to be very explicit in their agreement regarding these compromises, that this only relates to the current duration of the pandemic, and that thereafter all contractual provisions regarding timeliness must be observed again, so that there's no sort of course of conduct that has justified for the future any delays?
Yeah, well certainly it should be in writing, but I think it also depends on the party. So if you're, say, a tenant, I mean, yes, you may want to agree a concession on rent for 6 months, but even that 6 months period, are you going to be doing any business? Probably not much. So you would probably want to extend it further, or at that point, or at the end of the 6 months, we renegotiate again. So I think you need to allow for some flexibility where parties are having a dispute as to the time, you know, the type of accommodation that can be given to each party. But certainly it should be in writing. I think that would be very, very advisable.
Right. Gilbert Noël, we come to our final panelist for their initial presentation, and quite appropriately, you are last but not least in this lineup, because you will tell us a little bit about your view on the sort of worst case scenario. What happens if you really can't perform as a business entity? What are the options regarding insolvency and the like?
Yes, thank you, Andreas. Insolvency is one of the key words right now that businesses, lawyers, and everyone is talking about, and also restructuring. If I may use the analogy of the virus itself, some companies now are without symptoms. They are doing well. Others are quite okay. They are managing. Others may have some symptoms, but many companies right now, especially those in the hospitality business, are probably under life support, and others may not even survive. Like you mentioned, the courts right now are closed under confinement, but when the bankruptcy court will resume in Mauritius, we're not sure what to expect. And that brings us to the key question, and it's kind of the dark alley that we may see ahead. But I will kind of bring in a quote from Frank Borman, who said, "Capitalism without bankruptcy is like Christianity without hell." Yeah. So it's as if insolvency or restructuring is part of the business cycle, and I think we will witness that in the coming weeks, months, and years probably. And like we saw in the news today, even JCPenney in the States is considering bankruptcy. Okay. But from a legal perspective, in Mauritius, where I practice, there is no formal process for moratorium. The moratorium is more on a case-to-case basis, depends on the circumstances, and it's at the discretion of the judge, who will look at the merit of the time that the debtor is requesting and what are the conditions and the undertakings taken before court. It is not like a formal Chapter 11 in the United States, where there is a formal process of business rescue. That means the debtor, if it is considered as a good business, needs a temporary protection. The court will order a form of protection so as to allow a grace period for that business. And such a process is rarely seen. I mean, I'm not aware of any country in the region, in Southern Africa, Eastern Africa, that has such a formal process to allow and give companies a second chance. Presently, the banks and other lenders in Mauritius are buying in the policy of government to allow for moratorium. Okay, and this is being done on a more or less case-to-case basis, depending on the merits of the case. So that's kind of the first point I wanted to flag. The secondly is, whether it is in Mauritius, Seychelles, South Africa, and Eastern Africa, like our colleagues in Kenya and Zambia, we have seen substantial international transactions, cross-border investments, joint ventures. Okay. And so some of the insolvency or restructuring proceedings will take place not only in one country at the same time. There could be an order elsewhere. It could be from Europe, from North America, from Asia, but which affects a company in the region. And in Mauritius, we have recently enacted the cross-border insolvency provisions, which allow a foreign applicant, a foreign representative who has in hand an order from another jurisdiction, and that will allow him to seek the cooperation of the Mauritian courts, the bankruptcy court in Mauritius, and that they can have concurrent applications going on. But in general, I think we will see a hype in insolvency activities, restructuring, and probably mergers and acquisitions. That will go. The third and last point that I would like to make today is there is a major issue about director duties. If our laws, and like laws in most Commonwealth jurisdictions, provide that a director is under the obligation to call for a board meeting if he's aware that his company is not being able to pay its debts as they become due. Otherwise, the director may be personally responsible and liable to the creditors. This aspect is so sensitive that I understand that in the UK and maybe in Australia as well, they have suspended the unlawful trading provisions in respect of directors to allow them to still trade during these tough times. But I think that may require legislative changes, because if a director, in spite of the current situation, continues trading at the same time knowing that creditors may somewhere not be paid, those creditors could have recourse against him. So, but it would apply even if you are the board member of a bank, because banks now, they have to do this, and other lending institutions have to do this balancing exercise of allowing for moratorium, considering public policy, which their regulator, the central bank, will invite them to be involved into, allowing businesses to survive during these tough times. But I believe that at some point, those banks and financial institutions will take it to such a level that they do not, at a certain point, be exposed. So we will see interesting times for board members, financial institutions, doing such a balancing act between commercial fundamentals, risk, exposure, moratorium, and at the same time looking at public policy issues.
Very good. Very good.
I think the people in those positions should make sure that they take adequate advice and disclose all their views at board level, just to ensure that they are not personally exposed. Yeah.
Right. I think that is very good advice. And, you know, board members are now, you know, perhaps finally taken to task and not just flying around to meetings and sitting there and having catered lunches, but really are called on to carry their water, as the saying goes. And perhaps also, as the prior advice went, be proactive. You know, again, be proactive, as Mweshi said, as I think Fidel said as well. Whether it is renegotiating contracts as an individual business party, a small limited liability company, or whether it is as a board member, also be proactive and, you know, ensure that you individually or you as a corporation are performing the duties that are called for. And two very brief notes on your presentation, Gilbert. Thank you for that. I think one is, you know, as an antitrust and competition lawyer, we always think of economics, and there's this famous economic principle of Mr. Schumpeter, a 20th century economist who proclaimed that essentially every few decades there has to be a large destruction of vast parts of the economy for there to be an even bigger rebuilding. And perhaps and you sort of touched on this, that there has to be a lot of insolvency for there to be a lot of rebuilding. So maybe we are going through that period right now. The second point I wanted to raise, because you touched on a bunch of points that we published this is for our audience members now specifically, we published a note. It is on our website, on the primario.international website. There's a note that we all co-authored, you and Fidel and John, etc., regarding some of these points, regarding force majeure, all of the points that are raised during this panel. So the audience members are invited to download that. It is on the same page as the invitation for this event and also for the upcoming seminar next week, next Tuesday. There's an interesting question now, if I may move on to one of the audience questions from Kumar Ramasamy to all panelists. Kumar mentions that a lot of governments are invoking the word war and similar wording, speaking of frontline workers, for healthcare workers, etc. And in some countries, even the military, various branches, Army, National Guard, etc., have been deployed to, quote, fight, again, one of those warlike verbs being used there, the pandemic. So Kumar's question is, in light of this, this invocation of the word war and the like, could a party that lacks in its contract the force majeure clause that would cover the pandemic, let's say there's no force majeure clause at all in their contract, could they invoke the concept of war as a supervening, intervening effect, so as to essentially benefit from the concept of force majeure, even though the pandemic is not expressly covered? It's a very interesting question. And I guess if I start with my thought, it probably depends on whether there is an actual declaration of war, which I doubt any country has issued that yet. I think one might argue that linguistics are one thing, and an actual declaration of war, if that is required under your local constitution, that's another thing. But I open that up to our panelists if they wish to chime in.
May I say something on this?
Please, this is Judge Boulel.
I don't believe that the word war should be taken exclusively from the coronavirus situation. It must be linked to the virus, because it is a war to combat the virus. It is not a war in common parlance. Okay? So that we should not be misled just by the word war. It must be linked to the coronavirus. You see the way. Maybe as a lawyer, I would not have been able to give you a solution, but this is what I would have done as a judge. Now, secondly, if the contract does not have a force majeure clause, it can be invoked as a general principle, like in French law, a sort of a hardship provision, to say that, okay, because of that situation, this causes hardship in regard to my performance of my part of the bargain, and so I cannot perform it. Thank you.
I think to add on to what has been said, even if the words war and such like are being used, like Andres and Judge Blair said, there's really no war going on, and if there's no declaration of war, you can hardly rely on it. Then at the end of the day, whenever you are construing a force majeure clause, it has to be looked at in the context of the contract itself. What were the parties contemplating? What were you thinking of at the time that you drafted your force majeure clause? Was the war that you had in mind the war against coronavirus? So all those things will come in when a court is interpreting whether you can actually rely on COVID-19 as a force majeure event where you don't have wording to include pandemic and epidemic. So since you're looking at interpretation and construction of a contract, that word war is used loosely. It's hardly going to benefit anyone to rely on it.
I agree, Mweshi. Thanks, Judge. Thanks, Mweshi. I think Kumar's question is very creative, and it's an interesting, you know, as a measure of last resort prior to having to file for insolvency, as discussed by Jaber's topic. It might be a creative tactic of an attorney to invoke that. But I agree with both of you that I think it would have to be a very creative judge who hears that case, who grants the concept of war being invoked, barring a constitutional declaration of war. Anthony, you had dropped off there for a minute. Pardon, Fidel?
Yeah, I was just going to add something and say
yes,
that a lot of these government, and I think Kumar mentioned government regulations. So a lot of these businesses wouldn't be sending their workers home if not for government intervention. So the government is telling everyone, go home or work from home or maintain social distance. So these are regulations that have been put in place that now affect how businesses operate. So a business would have to shut down, maybe not primarily because of COVID-19, unless the pandemic spreads like it has in certain countries. So if it's in a country where it's spread to maybe there are like 10 or 15 cases, business would probably continue until the government issues regulations. And you'd find in certain force majeure clauses, government action can actually be a force majeure event. Yeah, government action that leads to disruption of business. So I think government action itself can be considered as part of it.
Thanks for addressing that, Fidel. That was also one of the questions raised by one of the audience members here. And another question that has now popped up, which I will also raise here, is and perhaps not just regarding Mauritius, but all countries really, but this is in the specific context of Mauritius. So I'll start with Gilbert. The concept of solvency requirements under the Companies Act in your country. Will it be loosened, do you think? Will it be enforced strictly by the courts, or will there be concessions made?
There are two aspects to the solvency requirements. Is first, we have what we call a solvency test, which is more an accounting exercise. You have to measure the available assets and the stated capital and so on. But that doesn't mean that you are not a going concern. You may fail the solvency test, but it doesn't mean that you are insolvent. The key question is whether you are being able to pay your debts as they become due in the normal course of business. That is the key thing. Once a debtor, a company, could be individual as well, we have provisions for personal bankruptcy. But let's assume here, for a company, it's not in a position to honor its obligations. So this is where you will lead to an insolvency situation. And when the creditor will take him to task, will send him a statutory demand. I did hear Judge Boulel he said earlier that in some jurisdictions, they have extended the delay for statutory demand. So these decisions will require legislative, they require new legislation.
Right, right.
Secondly, when we will appear before the bankruptcy judge, the judge may, of course, take into consideration the special circumstances of the virus and its consequences. But that, again, will be on a case-to-case basis. But the bottom line will be the company is unable to pay its debts, it will remain in a state of insolvency, and the law will have to be followed.
Right, right. And there will probably an avalanche of those cases. And then again, the delay of the courts may cause further insolvencies, ironically. That is sort of my informal and gut prediction, but everybody seems to be making those these days. I would like to wrap this up. We have about 6 minutes left. So if everybody could perhaps grace us and the audience with their closing thoughts, and I would like to do it in the following order. I'll start with Anthony, and then Mweshi, and then Fidel, the judge, Judge Boulel, and then Gilbert. So Anthony, your 60 seconds sort of wrap up of what you think perhaps people should look out for, whatever your closing thoughts may be.
Thanks, Andreas. I think my closing thoughts are, I think that there'll probably be a great temptation for many businesses and companies in this environment to engage in collective discussions or negotiations to try and enhance or improve their positions. But I think they have to take a long-term view of this and to make sure that they stay on the right side of the law, because I think that there may be some follow-on or catch-up regulatory processes when this is all over. And I don't think companies or executives want to expose themselves unnecessarily to regulatory follow-on proceedings, whether that's criminal or civil in nature. So I think I would just say resist the temptation to try and take desperate steps in desperate times, and if necessary, try and get block exemptions, try and work within the framework of the law as best you can, and try and resist the temptation to work outside of that, because it may have long-term negative consequences both for the company and for the executives concerned.
Thank you, Anthony. Mweshi, you're still on mute, but.
All right, there we go. My closing thoughts are this. To anyone, before you decide to invoke a force majeure clause, just ask yourself the following questions. Has COVID-19 actually prevented, hindered, or delayed my ability to perform? Because whilst it may be causing adding another layer to your business operations, you may still be able to fulfill your contractual obligations. So it's not an automatic trigger of your force majeure clause, so ask yourself that. Then the other issue is there an alternative method that I can engage to enable me perform my contractual obligation? If there's alternative avenues that you can employ, for instance, here in Lusaka, restaurants are not allowed to receive their patrons inside, but they can serve takeaway. So can you then refuse to pay your lease charges because you're not receiving your people? I think not. So you have to consider all those things. Is there an alternative? Can I get creative with the way I perform my business so that I can still survive this environment? Then the other issue is my non-performance of my contractual obligation due to COVID-19? If it's not, then really there's no reason for you to invoke the force majeure clause, but just get creative and also think of renegotiating.
Right, right. Mweshi has turned out to be the harsh taskmaster of this panel. What an interesting surprise. You are certainly reminding all our audience members that mitigation and causation are two important concepts. I think that's essentially, in a nutshell, what you just said. Mitigate and ensure that the cause is actually the pandemic. To keep that in mind. Fidel, your closing thoughts in a minute.
Okay, so my closing thoughts are that we should try and be as pragmatic and flexible as possible in our dealings with everyone, particularly our business partners. So you know, if you're a tenant in a building, the landlords try and be a bit flexible in terms of the kind of negotiations you can have with them. Employer-employee relationships as well. There should be some compassion showed. It's not a matter of, you know, oh, we can't do this, so, you know, you have to leave, you have to go. So parties, especially those who are in a stronger bargaining position, need to be a bit more cognizant of the situation that is present. And before they take any rash measures, they should actually consider how those measures are affecting their workers, their business partners, and so on. Thanks.
Thank you, Fidel. And Judge Boulel, closing remarks.
The virus will definitely go, but the issues it will leave behind will pile up. And these issues cannot be solved only by the willingness of parties to renegotiate or to give moratorium, etc. These issues must also be considered by governments with legislative changes in order to allow companies to function properly, in order to avoid what Fidel said in the context of employment, massive laying off of workers. Because if government doesn't intervene legislatively, that might be the tragic consequence of the virus, not only for debtors, but also for workers. Thank you.
Thank you. Thank you. And Gilbert, you get the last word before I let John thank everyone.
Yes, thank you, Andreas. When we listen and we see what's going on, I would really like to have known what the laws were like when there was a Spanish flu and what happened afterwards before the courts. I've heard about some litigation cases and judgments that happened then. I think we need to go back to 1 century ago, and I would be very keen to read those judgments. And just to say that our laws and current legislation in most countries did not provide or did not anticipate for such a crisis. And I think now this is where the leaders in all countries must sit down and really bring up the laws, legislation, and not only the members of parliament and so on, but also the institutions, academics, searchers and legal scholars and lawyers as well. We have to all put our minds together and see, basically, this is an opportunity, whether you are a businessman, a professional, or a small trader. It's also an opportunity to reinvent yourself. And I think that's how we should try to survive this and prosper afterwards.
We shall all follow your advice, Gilbert. And actually, your first point there about the old cases from the beginning of the last century regarding the Spanish flu is a fascinating thought. I had not had it. Thank you for giving me that. And I will literally log on to Lexis and Westlaw after this is over. And I encourage our audience members to do the same and see how far back the cases go. I think they might cover that, actually. So we'll take a look at that. John, you're the official host. Why don't you see us out the virtual door?
Yeah, well, from my perspective and learning new tricks, I think it's going to be a unique feeling when, if we all speak again, to be in an audience, before an actual audience rather than a virtual audience. But my extreme thanks to you all. I think this has been a tremendous success and certainly bodes well for the future seminar series. But each of the panelists, very insightful. To the audience, we will make this available on the website. And again, if there are any additional questions, please send those through on email. I'm sure we can address those to the panelists. Andreas, expertly done. Thank you very much. Again, thank you all. All right.
Thank you.
Au revoir. Bye-bye. Stay safe.